So welcome to our law school webinar. I think this is the fourth one that I've taken part in and spoke or hosted, and we've had Carol Lyons speak about Brexit, and now Yinka Lewis to speak about immigration, and I've spoken about extradition and Julian Assange and a couple other extradition cases in the past, and this is now a series of these, and we have got a couple more on the cards, and I hope you're going to find them, this one, informative and interesting. I'm pretty sure you will, and so thank you for coming. We appreciate it, and as Heather said, there will be an opportunity for questions at the end, and this topic is kind of interesting and an important one, and I'm sure some of you will have questions maybe in it from a general perspective, and perhaps even particularly, but of course we can't give out particular legal advice in our webinar. We have to speak in general terms, so I think we should be wary of that point as well. Okay, so as I've just said briefly, we're lucky to have my colleague Yinka Lewis here this early evening to speak about immigration law in the particular context of Brexit, which is still ongoing. Yinka is, I say, a colleague, a lecturer in a school, and a practicing solicitor in 2 jurisdictions, England, and I'm not sure if it's Scotland. I don't know what the second one is. He could put us right about that. I know he has experience practicing in immigration law before he joined us as a full-time academic 2 or 3 years ago, maybe even more now, and also oil and gas law experience. He's also reading for his PhD in the very final stages of that, and I'm sure we all could hopefully he's going to complete that with flying colors in not too long. And I guess more relevant to the webinar this evening, he's the head of the law clinic in the law school, where he meets people and passes on advice from and organizes others in the law school as well to do that. So I would like firstly to say thank you, Yinka, for coming on, and how Yinka and I discussed this prior to the start, and thought it might be useful if I would maybe like role play like a client in the law clinic with various questions that arise in a practical sense in the area of immigration law and Brexit developments, and put them to Yinka, and we'll go through a number of those, I think for just over half an hour, and then have questions, as I say. So that's the plan. Okay, so I'm just going to start off this just now and the first one, kind of a general question that would give us an introduction to the subject, and it is, what are the immigration-related aspects of Brexit? I'm sure this could take up our whole half an hour, but Yinka will be succinct. So Yinka, welcome, thank you. What are the immigration-related aspects of Brexit?
Thanks, Paul, for having me. I'm glad to be here this evening to share just the little knowledge I've got in relation to immigration law and Brexit. So the immigration-related aspects of Brexit it's a bit of a broad question, but I will try to be as brief as possible so we can cover the rest of the questions we have this evening. As most of you would know, or as most of us remember, after years of negotiations between the United Kingdom, between the government of the UK and the European Union, the UK formally left the EU on the 31st of January this year. The EU, as you know as well, is an organisation that had been, the UK had been a member since the 1st of January 1973, when it was known as the EEC, and that's the European Economic Community, which was set up to foster economic and political cooperation amongst member states. One key thing as well is that the EU was built on 4 freedoms, and that's the free movement of goods, persons, services, and capital. And the focus of today's discussions will be on the second freedom on which the EU was built, and that's the free movement of persons. It generally means that every citizen of the EU has the right to move and reside freely within the territory of any member state. This is pursuant to Article 21, one of the Treaty on the Functioning of the EU. Citizenship of the EU is enjoyed by persons holding the nationality of a member state of the EU. At present, all EEA, EU and Swiss citizens and their family members enjoy this freedom of movement rights within the UK. And they do so by what's referred to as exercising treaty rights. I will go into the process of exercising treaty rights along the way. But at the moment, I'll just talk about, I'll just leave that there for now. Now, in relation to the free movement of persons, because of Brexit, the free movement of persons will cease to exist, and EU nationals, EEA nationals, and Swiss nationals will be subject to UK immigration laws. And technically, from the 1st of January 2021, if there's no deal, or from the 1st of July 2021, if there is a Brexit deal in place. I'm just going to stop there for now in relation to the first question. So the key aspects, the key thing is the immigration-related aspects of Brexit relates to the free movement of persons, which we'll cover today. I'm not going to go into free movement of goods, services, and capital, because that's a lot more complicated, and we will not live here this evening. So I'll just stop there for now, and over to you, Paul.
Okay, thank you very much. That's a good basis for the rest of our discussion, and a hugely significant and important point. And we're going to, I guess, move on to the details of how this sort of momentous change of the ending of the free movement of persons after 27, what is it now, 47 years? I should have got that figure, after almost half a century, I think, but a momentous decision. So now I want to maybe put on a more specific and hat, or an applied hat, and I've got a couple joint questions that people in the EU, I think, have been thinking about now for a couple of years at least, and I imagine many of them would have acted on these, but some might not have, and some, I guess, just non-EU nationals living here might not be aware of them. So here's a couple of applied questions. As an EU national living in the UK, do I need to take any steps regarding my residency in the UK? So, and I don't even, I know that I think there's maybe 2 or 3 million, quite a large number of EU nationals resident in the UK. Do they need to take any steps regarding their residency in the United Kingdom? And then related to that, I suppose, a consequence of not doing that, if I wish to live in the UK beyond December 2020, do I need to do anything to remain in the United Kingdom legally? So really quite important specific questions, Yinka.
Yeah, the simple answer to those questions is yes. Going into more detail, as an EU national or a family member of an EU national, you need to take steps in order to ensure that you can remain in the UK after the 31st of December 2020. And the reason for that is because, as part of the Brexit deal, we're currently in what's referred to as a transition period, which expires on the 31st of December this year. The transition period is for the UK to finalize or formalize a trade deal with the EU post-Brexit. I mean, we're already outside of the EU anyway. However, if there's no deal reached by the 31st of December, it means we will leave the EU without a deal. If there is a deal after 31st of December, then we will leave with a deal. But yes, EU nationals living in the UK need to take steps to ensure that they continue to remain to live in the UK legally after Brexit. And the first step they need to take is to make an application under what's known as the EU Settlement Scheme, which I'll refer to as the EUSS. The EU Settlement Scheme, or the EUSS, basically allows EU, EEA and Swiss citizens and their family members, continued residents in the UK, and to get the status they need after Brexit. The status under the scheme protects them under UK law, and they continue enjoying rights to live in the UK afterwards. It's a simple, user-friendly process. I will go into details of what's required later, and yeah, so that's what they need to do. The other key issue there as well is who needs to apply. And so the persons that need to apply are EU nationals, EEA nationals, and Swiss citizens as well, and they are non-EU family members. So in terms of family members, you're looking at under EU law, the term family takes a much broad, it's looked at from a broader perspective. So under UK law, sorry, I will be switching between UK law and EU law because two different rules apply in relation to both of them. So for instance, somebody who lives, who holds the nationality of a non-EU country is subject to UK immigration law, which is based on immigration rules, the Immigration Act of 1971, and a whole list of other legislations as well. However, those who are from or who hold EU nationality or their family members are currently subject to EU law. And as part of this EU law is the EUSS, the EU settlement scheme. So EU nationals, EEA nationals, Swiss nationals or Swiss citizens and their family members are those that need to apply. Now, they have to be currently living in the UK for them to be able to apply. Under the EUSS, the length of residence in the UK does not matter. You can come in from an EU country today and apply under the EUSS tomorrow, because the key thing is that you're currently in the UK and you're resident. The length of time you've been living in the UK based on the EUSS is irrelevant. Individuals also with UK permanent residence or individuals who have applied under the current legislations as well. So you also have the Immigration European Economic Area Regulations of 2016, or referred to as the EEA Regulations of 2016, which is currently applicable to EU nationals as well. If you've previously made an application under those rules, you still need to apply under the EUSS. Applying under those rules does not exclude you from making an application under the EUSS. The other key thing as well is how and when should you make an application. The scheme currently is free. They used to charge £65 for it, but that position was changed a few years ago when the then Prime Minister Theresa May said it will be free to everyone who wishes to apply. So it's free to everyone who wants to apply. All you need to do is to have download the app on your phone and make an application following the steps on the app. It's a 3-step process as well. The first step is that you need to show that you're eligible. So basically you need to demonstrate, show that you're eligible to apply by proving your nationality and proving you've got no criminal convictions, and then demonstrating your residence in the UK. I'll talk about that in a bit. The other key thing I was going to mention is if you are an EU national or an EEA national or a Swiss national and you have lived in the UK for more than 6 years, rather than applying based on the EU settlement scheme, all you need to do is, if you can demonstrate that you've exercised treaty rights over that 6-year period, you do not need to apply under the EUSS. You can just go straight and apply for, you can apply to be a naturalized UK citizen if you want to, and if your country permits that. It's a slightly technical application, and I must warn at this juncture that with immigration applications, no two circumstances are the same. And please do not take this as advice. If you fall into that category, it's important for you to seek advice from a solicitor or from an immigration advisor who would advise you on the best course of action to take. The other key thing I was going to mention as well is the rules currently permit EU nationals until the 30th of June 2021 to make an application under the EUSS. The proviso to that is you have to have been resident in the UK as of the 31st of December 2020. So if you come into the UK on the 30th of December, you can make an application anytime before the 30th of June next year under the EUSS. If you come into the UK on the 31st of December as well, you can make an application. However, if you move to the UK from an EU country on the 1st of January 2021, you will not be entitled to make an application under the EU settlement scheme. And the rule only permits people who've been resident in the UK as of 31st of December 2020 to apply under the scheme, so long as they do it no later than the 30th of June 2020. Those dates are very, very important. The application process is, like I mentioned, a three-step process. And the first step is to prove your identity. Now, according to the Home Office, you need to have a valid form of ID. That's either a passport from an EU country or a national ID card. I know there might be questions on people whose passports have expired. You cannot use an expired passport to make an application under the scheme. And this is based on information from the Home Office. We've advised a few clients with the Law Clinic on the scheme. And I remember one of our clients coming in with an expired passport, and we had to seek clarification from the Home Office, and they confirmed that you cannot make an application with an expired passport. It has to be a valid passport or national ID card. If you're a family member of an EU national and you have the biometric residence permit, then you can use that to make an application as well. The second step of the three-step process is to prove your residence. Normally, you can use a national insurance number if you've been issued one by Her Majesty's Revenue and Customs, and the Home Office would use that to track your activity in terms of your residency in the UK. If you don't have a national insurance number, there's a wide range of documents you can use to prove your residence in the UK. The third step of the three-step process is the criminality check, and that's to check that you haven't got any serious criminal convictions. So issues such as parking tickets or police warnings, for instance, may not be considered as being very, very serious. But if you've been a convicted offender, or if you've got much more serious offences, then that might be an issue. But the threshold in relation to the criminality element of it is not as high as other types of applications, for instance. So that's a three-step process for that one. Yeah, I'll stop there for now. Oh, and then in terms of applications, it takes generally 5 working days. If you've got very straightforward applications, if the Home Office require further documents from you, it can take up to 30 days. And the guidance from the Home Office is if it takes longer than 30 days, then you are permitted to contact the Home Office to check on the status of your application. And most of the time, they are quite friendly. It's not like years ago where it was a different approach used by the Home Office, but now they take a much more friendly approach, and they're more willing to answer questions and provide an update on your application. So if you've made an application and it's been more than 5 days, or if it's been more than 30 days and you've not heard back from the Home Office, you might be able to check the status of the application. I'll stop there for now, Paul, and I'll take the next question. Over to you, Paul.
Okay, well, thank you very much. A wealth of information there. If I just have one sort of brief follow-up question, then I'll move on to settled status and pre-settled status. So the critical date was the 31st of December 2020. And so that, and you mentioned about people moving from other EU countries to the UK, they would have to do it prior to that date in order to be eligible to make an application, right? What about the 3 million people, EU nationals already living here? I assume they have to, no, I guess that date doesn't apply to them. The date that's critical for them is June 2021 if they're already here, is that right?
That's right, yes. So the date critical for those already in the UK is 30th of June 2021. And in my opinion, I think the reasoning behind that date is because after 30th of December 2020, EU nationals and what's people who are classed as non-visa nationals, so nationals of the United States of America, Canada, Australia, who can come to the UK, and they can come for up to 6 months. So the same principle is applying to EU nationals who have not or who do not intend to apply under the EU SS. They can stay for up to 6 months. But after, then they would have to regularize their stay if they want to continue living in the UK. Hence the 6 month period or the 6 month deadline to make the application under the EU SS for those already living here.
Yeah. Okay. Thank you for that. Sorry, I threw a curveball and asked you a question that wasn't on my list. I'm sorry about that. But very good. Thank you very much. Okay. So now I've heard of, you mentioned, SS settled status. I've also heard of pre-settled status. Is there a difference between pre-settled and settled status?
Yes, there's a difference between pre-settled status and settled status, and the difference is this: the difference is in the length, in relation to the length of residence in the UK. So if you've lived in the UK for up to 5 years or more, then when you apply under the EU settlement scheme, the status you will get is the settled status, and that's just it's just terminology. It means the same thing as permanent residence, or it means the same as indefinite leave to remain for applications granted under the immigration rules. For those who have not lived in the UK for up to 5 years, then they are granted what's known as pre-settled status. And so long as they continue living in the UK, so long as they live in the UK continuously for 5 years, once they hit that 5-year mark, they can then apply for settled status, or what's also known as permanent residence.
Okay, that makes sense. So then I guess to the next stage, someone has applied successfully for settled status. Does that mean they become British citizens as a result of being given settled status?
Unfortunately, no. So if you have settled status and you want to become a British citizen, you still need to take steps to make an application to become a British citizen. Now, that's a good question, because this is where it gets tricky. At the time the government made provisions under the EU settlement scheme, they completely removed the requirements to pay an application fee. The requirements were not very, very strict, especially when compared to other applications made under the immigration rules. And the requirements were also not as strict when you compare it to requirements made the requirements for applications made under the EEA regulations of 2016, which is previously EEA regulations of 2006. So if you get settled status and you want to apply to become a British citizen, so long as your country of original nationality permits that to happen, then you will need to apply for what's known as naturalization. Make an application for naturalization to be a British citizen. And that applies to people who are 18 and over. For those who are 17 and under, they will need to make what's known as an application for registration. Both mean the same thing. It's just a question of terminology for either. Now, the requirements for applying for naturalization are a lot stricter than applying under the EU settlement scheme. And that's because for naturalization, you need to ensure that you satisfy not just the requirements of the British Nationality Act of 1981, but also the requirements of the immigration rules as well. And this includes, you need to demonstrate that you have knowledge of English language, so you need to be able to speak English. Either this is demonstrated in the form of taking an English language test, or if you have a degree that was taught in English, or if you are from a majority English speaking country. So say, for instance, you are from Finland. I'm just using Finland as an example, and this is not specific to anyone particularly. Say you're from Finland and you studied in English in Finland. The fact that you studied in English in Finland is not sufficient for you to demonstrate evidence of English language ability. And that's because Finland is not a majority English-speaking country. So you will need to get a letter confirming that the degree from Finland is equivalent to a degree from the United Kingdom. And secondly, you will need to satisfy or demonstrate knowledge of life in the UK. And this is simple, you just need to take the Life in the UK test. You also have to demonstrate that you satisfy the residency requirements, and particularly, or most importantly, you need to demonstrate evidence of good character. This is important because evidence of good character is, the Home Office takes, or the rules take a very, I would say, a subjective approach to it. So for instance, if you've had multiple speeding tickets or warnings, that may question your good character capability, and it might be an issue in, I'm not saying it would, I'm just saying it might be an issue when you want to apply for naturalization as a British citizen. Now, what's very, very key, and what's the most important thing, is the fact that when it comes to applying for naturalization, you have to demonstrate that you've complied with immigration regulations in the UK. That's important because if as an EU national, you lived in the UK for say 10 years, and you were able to demonstrate evidence of exercising treaty rights, you also have to demonstrate the requirements needed to demonstrate treaty rights. I will explain that. So if you're a student for 10 years, for instance, or you studied for say 8 years and then you started working for 2 years, the period that you were a student for, you need to demonstrate that you had what's known as comprehensive sickness insurance. You might find people who would have issues making applications for naturalization because they don't satisfy that particular requirement. Again, it's important to speak to a solicitor or a legal advisor if you want to make such applications. I was also going to mention as well, in relation to settled and pre-settled status, so far there have been more than 3.7 million applications made so far. As of, I think it was the end of July, but based on Home Office figures or statistics, the top nationalities that have applied are Poland, Romania, Italy, Portugal, and Spain. Of those 3.7 million applications, 3.4 million applications or applicants have been granted status, either pre-settled status or settled status. And more than 50,000 applications were made on the opening weekend of the scheme being made available to everyone. And this was on the 30th of March, 2019. I just thought I'd just give those statistics as well. Yeah, I hope that covers the questions, Paul.
Yeah, that was a very interesting answer. And if I'm allowed, I'd just make ever so brief comment and then we'll move on to our next one. But what was ringing or spinning around in my mind as we were speaking, I said, well, if one has settled status, why would they bother becoming a British citizen? What additional rights they would get as a result of that? And I don't want you to answer this. And so one thing that I was personally interested in was terrorism and deprivation of nationality, where somebody had British citizenship and it was taken away, you know, the famous Shamima Begum. And so to my mind, if you're a British citizen, perhaps you'd feel more secure in your attachment or status within the United Kingdom, but that isn't necessarily the case. And so I'm just wanted to mention that, but we can move on because I don't think we have time. But you know, I think there's consequences obviously between, or differences between being a British citizen and having settled status, perhaps voting or in others, isn't there? But okay, we can maybe come back to that because we got more practical questions. So say you're in work here at RGU. I know we've got a number of people in this boat, and your status changes. Would you have to inform your employer of the change in your status?
Not necessarily. If you're an EU national, and you've informed your employers at the time you gain employment or at the time you started working with them, the fact that the rules still apply, the fact that the current rules have not changed, means you're not required to do that. However, well, from the 1st of January up till the 30th of June, it's sufficient for you to present your passport as evidence of your rights to live in the UK as an EU national. However, after the 30th of June 2021, it will be a legal requirement for you to demonstrate your right to continue living in the UK. So you need to show them that you've applied for pre-settled status or settled status, or that you've applied and been granted an application for naturalization.
Okay, great, thank you. I think you alluded to this question, but maybe you could just brush it over in it quickly then. That was, I do not have a valid passport. Can I make an application under the EU settlement scheme? Have you already alluded to your answer to that one?
No, you can't. You must have a valid passport to make an application, and a valid passport is a passport that is still in date. Obviously, if you don't have a passport and it's not possible for you to get one, then you would have to inform the Home Office. But it will be almost impossible for you to make an application under the scheme using the phone app, because currently most applications are done via the phone app. In such circumstances, it will be necessary for you to post, or for such an applicant to post their application directly to the Home Office. It will take a lot longer as well, but yeah, it may be possible, but it will have to be posted to the Home Office.
Okay. This is probably a relevant question for a number of people. An EU national, or here the question is, my spouse is from outside the EU. Can they apply under the EU settlement scheme?
Now that's a good question. Yes, spouses can apply under the EU settlement scheme. However, they will need to demonstrate evidence of relationship. So if they're a spouse, they'll need to provide the marriage certificate to demonstrate that. What I've noticed and what I've found out from experience of making applications is, with some applicants, the Home Office requires marriage certificates. With some applicants, the Home Office don't require marriage certificates. I don't know the reason for that, but the suggestion here will be, if you're a spouse of an EU national, it's just best for you to provide your marriage certificate as part of your application. It to save you time, and it to sort of remove the need for you to provide additional documents later if the Home Office requests for them.
Okay, thank you. That question reminds me of my own personal experience, where I had to go through a process of becoming a lawfully resident in the UK, coming here as a student firstly, and then I got a job, so it was through a work permit from a 3-year fixed period, and then I got married in the interim, and so I changed my immigration status to be here to get indefinite leave to remain by virtue of my marriage. And I remember I had to go to Glasgow airport and meet an immigration officer there, and with my wife, and we had a chat, and that was all fine. But that was the process 25 years ago or something, or other 23 years ago. Anyways, that's nothing to do with what we're talking about now. Okay, so I'm sorry for that aside. Here's another one. I'm an unmarried non-EU national, and I've lived it with my partner. We have a child together. Can I apply under the EU settlement scheme?
That's a good question. So there is provision for married couples or couples in civil partnerships to make applications under the EUSS. However, it's a slightly different approach for people who are not married, or people who are not married and have children. I'll take both of them together. You can make an application if you're unmarried and if you have a child together. And you can make the application if you're able to demonstrate evidence of cohabitation for at least 2 years. So if you have a partner who you're not married to and you've lived together for 2 years, then you need to provide evidence of cohabitation for the 2-year period or more before you can make an application. It will be slightly difficult if you've not lived together for 2 years and intend to make an application. The likely chance of success for such an application may not be very high. If you are not married and you have a child together, there's what's known as evidence of durable relationship. And the fact that 2 unmarried people have a child together makes such an application strong. So a person who's unmarried with a child making an application would likely have a higher chance of success in relation to someone who's unmarried with no child making an application, where both of them have lived in the UK for less than 2 years. But the general answer to that question is you need to demonstrate evidence of cohabitation for at least 2 years as an unmarried couple or unmarried partner of an EU national before making an application. It is important to note here as well that both the couple, at least one of them must be from an EU country. So you can't have two non-EU nationals, for instance, applying under the EUSS. No, you must be an EU national, EEA or Swiss national, or a family member of any of them.
Okay, great. Thank you. My penultimate question, and a negative one, and unfortunately has happened, I suppose, to some people through the stats you gave earlier. If my application is refused, what can I do? Is it the end of the road, or is there an appellate procedure or some sort of reevaluation?
Yes, you can appeal decisions, refusal decisions to the Home Office. That provision came in February. Previously, you couldn't. But you can make representation to the Home Office, say, well, you've refused the application and I need you to review it. So yes, it is possible to make representations to the Home Office in relation to a refused application under the EU settlement scheme.
That's relatively novel, only February this year. Do you have any stats? I wonder, would you have any joy? I mean, the impression that I get from the Home Office in an extradition context is, you know, it doesn't budge much. You know, a big bureaucratic institution that's you know, maybe unwilling to change its mind.
The different sort of in terms of getting the Home Office to review decisions, you could do what's known as an administrative review, which goes to the Home Office directly. It's just a case of getting a more senior caseworker or a more senior person to review that refusal decision that has been handed down to that particular applicant. You could appeal the refusal decisions to the Immigration Tribunal, and the alternative, the other option is to make an application for judicial review, but that takes a lot longer. The process it's much more complicated, and it's just not advisable to do that on your own. If you intend to, just get a solicitor to do that, or a barrister, or an advocate, since we're in Scotland.
Yeah, I suppose there would be legal fees or fees, you know, attached to that. So, and you would probably not get legal aid, would you? I don't know.
Yeah, there will be legal fees attached in relation to paying solicitors to do that for you. Legal aid for immigration cases are generally, they've been withdrawn now for the most part. There are still some areas of immigration that you may be able to get legal aid, but generally, you wouldn't get legal aid for immigration.
Yeah, it's such an important subject for somebody, you know, and then, you know, unable to get assistance if they can't afford it themselves is really quite draconian, I would have thought. Okay, the final question, more of a general one, and kind of getting back to the start where we spoke about, you know, the UK's entry to the EU, free movement, and this fundamental freedom of free movement is now coming to an end. And people would have different views on this, sort of maybe it's an opinion question. Does Brexit open opportunities for people, or does it merely just close a door, slam a door shut to, you know, millions of Europeans who might be minded or in the past have minded to come here to work?
That's an interesting question, and it depends on what perspective you look at it. So if as an EU national you're intending to come here on the 1st of January or after the 30th of December 2020, the answer to that question will be no, because you would no longer enjoy the free movements that you would have enjoyed when the EU was in the EU, when the UK rather was in the EU. So in terms of opportunities for EU nationals looking to come to the UK, no, the opportunities wouldn't be there anymore. So the answer to that is it's a no. However, also in relation to family members of EU nationals, the doors basically will be closed from next year, and that's because currently the definition, like I mentioned, of family under EU law takes a much broader approach in relation to the definition under UK law. So, for instance, under EU law, family members are classed as spouses or civil partners, direct descendants, so children, grandchildren, of an EU or EEA national, or children and grandchildren of the EU national's spouse or civil partner, so long as they're under the age of 21. And then you also have family members who are direct and dependent direct relatives in ascending line, so parents and grandparents of an EU national and of the EU national's spouse. So I'll just give an example. I'm not an EU national, but let's assume I was an EU national. If I were married to a non-EU national spouse, it means my wife's parents would be entitled to come here. Her grandparents will be entitled to come here as well. My wife's children or grandchildren, if she had, will be entitled to come. But from the 1st of January next year, all that is going to stop. And the definition of family will be based on the definition of family under the immigration rules, which is a spouse or civil partner or children who are under the age of 18. It doesn't allow for parents or relatives. However, you may be able to bring in parents under what's known as the visa referred to as adult dependent relatives. The requirements for granting of such visas are very, very strict. And yeah, if you don't satisfy those requirements, it's just not, the likely chance of success for such applications will be difficult. So for such family members of EU nationals, Brexit is not, it's not a good thing for them. However, for people who are non-EU nationals coming to the UK, it means there's the requirement for them to make applications for, say, they wanted to apply for jobs in the UK. Currently, employers have to demonstrate what's known as they have to carry out what's known as a resident labour market test, which means they have to offer that job or demonstrate that nobody who is British or who's from the EU has the requirements or has can fill that position before it's offered to a non-EU national. So it depends on what perspective you look at it. But the key thing, though, for EU nationals is that it will be expensive. So granted, making applications under the settlement scheme is free, but if they want to make applications for naturalisation, at the moment it's £1,349.60. It's a lot of money, and that there's no guarantee that those applications will be successful. And if it's refused, they lose the money completely. And from 1st of January, EU nationals would also be subjected to making applications under what's known as a point-based system. So they would have to meet points for different categories in order to apply for visas to come to live, work, or study in the UK. So it depends. For EU nationals, it's not great, basically, because of the new requirements they would have to meet, and because of the removal of the freedom of movement. However, for non-EU nationals, it opens more opportunities for them as well. So it all depends on what perspective you look at it from.
Great, thank you. That's an excellent answer. I guess just purely from our geography, though, and our previous links being with the other EU members, it appears to me at first sight maybe to be overwhelmingly negative as opposed to positive. But I'm also a Canadian, and maybe there maybe is some chinks of light in this whole saga.